courtroom was silent, too silent. You could almost hear the tension humming under the fluorescent lights as Judge Beryl Howell leaned back in her chair, lips curled in that half-smirk that said, "I've seen everything before." Across the aisle stood Congresswoman Jasmine Crockett, part fire, part storm, and entirely too calm for someone about to challenge both the Department of Justice and a federal judge's patience. The case. A state-level voter roll purge accused of quietly deleting thousands of minority voters through a supposedly neutral algorithm. But Crockett wasn't buying it, not for a second. The what? A motion to compel the government to produce every hidden line of that algorithm's code. The why? Because something about it stank deeply and mathematically. The who? Jasmine Crockett, civil rights attorney turned congresswoman, walking into that courtroom with the confidence of someone who's already read the ending of the story. The how? By using data sharp enough to draw blood. And the when? The very morning Judge Howell expected another routine motion until Crockett flipped the script. "Your Honor," Crockett began, her tone deceptively casual, "the code they've provided is incomplete." She clicked her remote and the projector flickered to life. On the screen appeared blocks of code annotated in red. "Here, notice the external calls. These reference missing modules. And those modules," she said, letting the pause hang like a guillotine, "contain the weighting factors for voter removal." Judge Howell raised an eyebrow. "You're saying the government intentionally withheld them?" "I'm saying the algorithm's brain is missing," Crockett replied, "and the part they've left out decides who gets to vote." The DOJ attorney shifted in his seat, visibly annoyed. "Your Honor, this is a fishing expedition. We've complied with all discovery requests. Every line of relevant code is already." But Crockett wasn't finished. "Relevant when 83.6% of flagged voters come from minority census blocks that represent just 24% of the population," her tone sharpened. "That's not a coincidence, that's a bias wearing a badge." A low murmur spread through the courtroom. Judge Howell tapped her pen, unimpressed. "Counselor, that's quite a conspiracy theory." Crockett smiled. "Conspiracy theories don't usually come with math, Your Honor." The line hit like a jab. Even a few reporters cracked grins, but Howell wasn't laughing yet. She leaned forward. "And what exactly are you asking for?" "Full production of the algorithm," Crockett said simply. "All modules, all logs, all documentation, including any communications about modifications to those modules." The DOJ attorney scoffed. "Preposterous, those files are classified." Crockett didn't blink. "Classified bias, that's a new one." The room chuckled. Momentary release from the mounting pressure, but everyone knew this was just the warm-up. Crockett's expression hardened as she continued. "Your Honor, we have evidence, internal developer emails that suggest certain modules were deliberately withheld from discovery. That's not a clerical error, that's concealment." Howell tilted her head, skeptical. "And where did these emails come from?" "That's when it happened, the moment that would later make national headlines." Judge Howell let out a sharp, dismissive laugh, not cruel, not mocking, just the kind of laugh that said, "This is absurd. Counselor, you can't seriously expect this court to entertain ghost code and secret cabals of developers." Crockett didn't flinch. She simply reached into her folder, pulled out a stapled packet, and slid it toward the clerk. "Exhibit C, Your Honor." But what happened next shocked the entire courtroom. Judge Howell glanced at the first page, then the second. The laughter drained from her face like light from a dying star. The document contained internal emails, real ones, between state IT officials and private contractors discussing segregating demographic weighting factors and creating alternate documentation for litigation purposes. In other words, fake files to hide racial data links. The judge's pen froze midair. She looked up, eyes narrowing. The silence was suffocating. Then, in a tone stripped of all amusement, she said, "We'll take a 15-minute recess." 15 minutes, that's all it took for the courtroom's entire energy to flip. The DOJ attorney sprinted to the hallway, phone glued to his ear, muttering into it like a man trying to stop a collapsing dam. Reporters whispered furiously, typing headlines they hadn't dared dream up this morning. And Crockett, she just sat there, serene, almost bored, like a chess player watching her opponent realize they'd been in check 3 moves ago. When court reconvened, Judge Howell's demeanor had changed. No smirk, no skepticism, just cold precision. "I have significant concerns," she began, "about the completeness of the government's discovery production. The authenticity of these emails appears credible on preliminary inspection." The DOJ attorney tried to recover. Your Honor, we can't confirm the chain of custody for those emails. Then confirm it, Howell snapped. You have 3 business days to begin full production of the missing modules. I also expect an internal report on the discovery process. The entire courtroom knew what that meant. Someone at the DOJ was about to have a very bad week. Crockett, however, wasn't done. Your Honor, given the nature of this concealment, we request immediate appointment of a neutral technical expert to review the algorithm. Judge Howell paused. This was a gamble. Appointing an expert meant officially acknowledging potential misconduct. It meant headlines, it meant pressure, but Howell was no coward. She nodded. Motion granted. The court appoints Dr. Eleanor Chan as independent expert. And just like that, the case detonated into the public consciousness. Outside, reporters were already hounding DOJ spokespeople. Did the government hide algorithmic bias? Was the voter purge racially motivated? How could emails like these exist? Inside, Crockett delivered one final dagger. Your Honor, she said softly, for the record, we appreciate the court's willingness to approach this with humility. Technology should never become the mask behind which discrimination hides. That line would later be quoted in law schools for years, but at that moment it simply landed like thunder. 3 days later, the missing code was produced. Dr. Chan began her analysis, her report eventually confirming what Crockett had suspected from the beginning, the so-called demographic correlator. It didn't use race fields directly, it didn't need to. It used proxies, common first names, regional surnames, even zip code clustering. The result? Minority-heavy neighborhoods were flagged for voter roll verification at rates triple the norm. But rewind to that first day right after recess, right after Howell's laughter vanished and the atmosphere was electric. You could feel a shift, not just in tone but in balance. Howell, once the stern skeptic, now looked like someone realizing she might have just witnessed a cover-up unfold in her own courtroom. Crockett leaned on the table, voice measured but cutting. This isn't about politics, Your Honor, it's about math. Algorithms don't have intent, but their creators do, and these creators taught the system who to distrust. The DOJ attorney tried to interject. Objection. Overruled, Howell snapped before he even finished. The transformation was complete. The same judge who had laughed 15 minutes earlier was now the one defending the line of inquiry she'd mocked. By the time recess ended, the tension in that courtroom could have been bottled and sold as rocket fuel. Howell adjusted her glasses. Counselor Crockett, your diligence in pursuing this matter has uncovered a serious issue that might have otherwise gone unnoticed. Crockett nodded respectfully, but the faintest smile tugged at her lips. Then came the hammer. Until further review, this court issues a preliminary injunction halting all voter purge operations and ordering immediate reinstatement of any individuals previously removed by this algorithm. The gasp that followed was audible. Reporters practically dove for their phones. It wasn't just a legal victory, it was a moral explosion. A congresswoman had walked into federal court, accused the government of algorithmic discrimination, gotten laughed at by the judge, and walked out with a historic injunction. But this was only the beginning. Because within 48 hours, media across the country picked up the story. The algorithm that could count fairly, Congresswoman exposes digital discrimination. Even late-night comedians joined in. One joked, the algorithm was so biased, even autocorrect refused to fix minority names. Crockett laughed when she saw that clip, but her expression turned serious during interviews. This isn't comedy, this is democracy on trial. Back in the courtroom, Judge Howell had convened an emergency conference call with DOJ supervisors. Her voice, once measured and formal, now carried a new edge. If your department cannot produce documentation explaining how demographic data was handled, this court will consider sanctions for discovery misconduct. The DOJ attorney's silence said everything. Meanwhile, Crockett's team discovered more. Backup files showing developer notes explicitly mentioning optical exclusion of minority clusters to reduce false positive verification matches. Translation: they coded the system to double-check minority voters more often than others. By this point, the energy in the courtroom had shifted entirely. Howell was now scrutinizing every DOJ statement like a hawk. Crockett's once dismissed conspiracy theory was fast becoming judicial fact. And when Dr. Chan's preliminary findings confirmed that certain modules applied demographic multipliers to purge scores, the case's moral gravity became undeniable. Still, Crockett didn't gloat. "We're not here to win headlines," she said during recess. "We're here to make sure democracy doesn't get debugged out of existence." That single quote went viral overnight. Comment sections filled with praise and trolls. Some called her a hero, others accused her of data witchcraft. But even her critics couldn't deny she'd forced the justice system to confront something uncomfortable. When code replaces conscience, who gets erased first? In the days following, the DOJ's internal audit admitted unintended oversights in documentation. Howell's response was brutal. "Oversight? You mean deleting evidence and pretending it never existed?" Her tone cut through the courtroom like steel through silk. By the end of that hearing, even the DOJ attorney looked like he wished he'd called in sick. But Crockett, she sat there unshaken, flipping through her notes, already 3 moves ahead. She knew the next revelation would redefine the whole debate, not just about voting rights, but about how technology itself could become the next Jim Crow. And that revelation was coming next. The second phase of the trial began with a kind of tense anticipation that only happens when everyone knows history is about to be written. But nobody knows whose ink it'll be written in. Judge Beryl Howell re-entered the courtroom, her face unreadable, the same face that had laughed at Jasmine Crockett only days earlier. But this time there was no laughter, no smug certainty, just the quiet intensity of someone now painfully aware that the law had nearly been manipulated by a line of code. Crockett stood ready, crisp, and composed, her hands clasped behind her back. The DOJ table, meanwhile, looked like a war zone, files everywhere, lawyers whispering frantic strategies that all seemed to end with, "We're screwed." The what was clear: Dr. Eleanor Chan's report had landed like a meteor. The why: because it confirmed the missing module wasn't missing by accident. The who: state officials, DOJ liaisons, and at least one private contractor knew exactly what they were doing. The how: by creating a demographic correlator, a code function designed to predict citizenship validity likelihood using patterns statistically tied to minority populations. The when: months before the purge began, long before oversight committees could have intervened. And the where: buried deep in a server room few people even had clearance to enter. Judge Howell began. "Dr. Chan, please summarize your findings for the record." The expert adjusted her glasses, voice steady but laced with disbelief. The concealed module utilizes proxy variables, surname frequency, geographic clustering, and historical registration inconsistencies to produce a weighted risk score for potential ineligibility. These variables are not racially labeled, but they correlate almost perfectly with minority communities. In effect, race was encoded through inference. You could hear the gasp ripple through the courtroom. Crockett didn't move, didn't gloat, she just let the silence do the work. Judge Howell exhaled slowly. "In plain English, Doctor." "It means," Dr. Chan said bluntly, "the system disproportionately flagged Black, Latino, and Asian American voters. Statistically impossible to be coincidence." The DOJ attorney leaned forward. "Your Honor, even if this occurred, it was unintentional. There's no evidence of malicious intent." Crockett's response cut him off like a scalpel. "Intent? They literally wrote an internal email titled alternate documentation for litigation purposes. That's not intent, that's premeditation." The courtroom erupted in murmurs again. Howell slammed her gavel once. "Order." But the damage was done. The DOJ's defense had just imploded in real time. Crockett pressed forward. "This was never about one bad line of code, it's about an entire system built to look neutral while acting racist. They didn't just delete names, they deleted voices." Even the stenographer paused, momentarily startled by the rawness of the line. It wasn't a speech, it was a sentence carved into the walls of history. Then came the twist nobody saw coming. As Crockett's team prepared to rest their argument, one of the junior DOJ attorneys requested to approach the bench off record. Judge Howell agreed. After a tense sidebar lasting nearly 6 minutes, Howell's expression turned pale. She leaned back and said, "Mr. Reynolds, please repeat that for the record." The young attorney hesitated. "Your Honor, certain officials instructed the technical team not to preserve the training datasets used to calibrate the algorithm. Those datasets included racial demographic breakdowns." The courtroom froze, Crockett's head tilted slightly, eyes narrowing. You mean, Howell said slowly, the foundational data was destroyed? Yes, Your Honor. But why? The attorney swallowed hard, because it would confuse litigation optics. There it was, the smoking gun nobody expected mid-trial. Crockett blinked once, twice, then said softly, Your Honor, that's evidence tampering. Howell didn't respond, she didn't need to, her expression was answer enough. A wave of collective realization swept the courtroom. What began as a conspiracy theory had now evolved into a full-blown government scandal. Reporters were whispering, cameras zooming, even veteran lawyers looked rattled. Crockett turned to the DOJ table, voice measured but lethal. You can scrub code, you can shred paper, but you can't hide patterns. Truth always leaves a signature. That line instantly trended on social media under Truth has a signature. But Howell wasn't here for hashtags, she was here for accountability. Effective immediately, she said, this court is expanding the scope of review. I am referring the matter of data destruction to the department's Office of Inspector General. The DOJ lead attorney sank in his chair. Crockett continued, now in complete command. Your Honor, given that the datasets are gone, we request the court order reconstruction using public and archived registration records. Transparency demands it. Granted, Howell said before the government could even object. You have until the end of the week to facilitate that process. Tension, release, new tension again. Every loop pulled the viewers deeper into Crockett's quiet storm. But as the DOJ struggled to contain the fire, something remarkable happened. Judge Howell looked at Crockett not as a challenger but as a colleague in the pursuit of truth. Congresswoman Crockett, she said, this court recognizes your diligence. You've demonstrated technical expertise rarely seen in advocacy of this nature. It was more than praise, it was validation. The same judge who once dismissed her now stood publicly acknowledging her as the architect of one of the most significant legal breakthroughs in modern civil rights litigation. Crockett gave a small nod. Thank you, Your Honor. It's not about brilliance, it's about paying attention where others choose not to look. That line too would echo in law schools. Then came the release of Dr. Chan's final report. It didn't just confirm bias, it quantified it. The algorithm, she wrote, reduced voter eligibility confidence by 0.7 for each occurrence of certain surnames statistically linked to Black or Hispanic heritage. Translation: if your name sounded like Deshaun or Rodriguez, you were 40% more likely to get flagged for removal. Howell read the report in stunned silence. Dr. Chan, in your professional opinion, can this system be corrected? Chan shook her head, not without rebuilding from the ground up. The bias is structural, it's embedded in the assumptions, not just the data. The judge's eyes hardened. Then we won't correct it, we'll end it. And with those words, she issued the order, a permanent injunction halting all algorithmic purges statewide, plus the reinstatement of every wrongly removed voter. The gavel dropped like thunder, and in that instant, history shifted. But what happened next wasn't legal, it was cultural. The ruling triggered a chain reaction across the nation. Other states began auditing their systems. Legislators drafted algorithmic transparency acts. Activists rallied online, quoting Crockett's now famous line, "Technology should never become the mask behind which discrimination hides." Even Judge Howell became an unexpected icon. During a post-case symposium, she admitted, "I laughed because I didn't understand. I'll never make that mistake again." Judges must approach technical evidence with appropriate skepticism and appropriate humility. Crockett, when asked about that moment, smiled. "We all laugh before we learn," she said. The important part is that she listened. But in the courtroom of public opinion, the drama refused to die. Commentators painted Crockett as a digital age crusader, the woman who taught America that bias doesn't always wear a hood, it sometimes wears a user interface. Meanwhile, the DOJ scrambled to repair its image, releasing new discovery guidance mandating full disclosure of all technical components in systems affecting constitutional rights. It was the bureaucratic equivalent of a confession. And in law schools, professors began teaching Crockett v. Howell as the defining case for algorithmic accountability. Mock trial students loved reenacting the laugh, the dismissal, the reversal, the redemption. But here's what the headlines missed. For Crockett, the victory wasn't about humiliation or revenge, it was about prevention. She later told an interviewer, "We didn't just stop one purge, we stopped a precedent." Yet beneath the triumph, there lingered one final twist. During post-trial review, it was discovered that a handful of other states had quietly licensed the same algorithm under slightly different names. Crockett stared at the documents, half smiling. "Looks like the fight just went national," she said. Her aide asked, "Are you going after them too?" Crockett glanced up, eyes sharp as ever. "No," she replied, "we're going after the mindset that built them." That single line became the closing scene of every documentary that followed. It wasn't just a legal victory, it was a philosophical shift. The courtroom had become a battlefield where intellect outmaneuvered institutional arrogance, where data met justice and justice finally won. But the beauty of this story wasn't that the hero won, it's that she converted the villain. Because by the end, even Judge Beryl Howell, the woman who once laughed, became a believer. She transformed from skeptic to sentinel, now warning other judges against the very blindness she once embodied. And that, perhaps, is what makes the story timeless. In a world obsessed with artificial intelligence and algorithmic efficiency, it reminded us of one unprogrammable truth: fairness requires feeling. Machines can measure, but only humans can care. So when the final ruling came, Howell's closing words weren't procedural, they were poetic. "This case is a warning," she said. "Technology is only as just as the hands that code it, and justice, as we have seen, still requires a heartbeat." Crockett looked up, nodded once, and smiled faintly. "Then let's make sure it never flatlines again." The gavel struck for the last time. Outside, a cold wind swept across the courthouse steps where reporters swarmed and flashbulbs popped. Crockett stepped to the microphones, her tone calm but commanding. "We didn't expose an algorithm, we exposed a mindset. Justice isn't about who laughs last, it's about who refuses to stop fighting until truth gets the microphone." She turned and walked away as the cameras flashed, leaving the nation buzzing and the DOJ scrambling to rebuild. Behind her, the words Crockett v. Howell would soon become synonymous with one idea, that in the age of code, conscience is the new revolution. And somewhere inside that courtroom, Judge Beryl Howell sat alone at her bench, quietly whispering the same line she'd once dismissed with laughter. Technology should never become the mask behind which discrimination hides. The irony wasn't lost on her, but neither was the lesson. Because sometimes justice doesn't just punish the guilty, it enlightens the blind.